Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to the NPTEL online certification course. Our course title Medical Law. So, as you know, we are at the 6th module Medical Jurisprudence and Forensic Science. So, we have discussed various lectures in this module. So, today we will be discussing the further lectures about the medical jurisprudence and the forensic science. Myself, Dr. Chaitanya Mittal, medical legal consultant at Dr. B.C. Roy Multi-Specialty Medical Research Center, IIT Khanpur. So, today we will be discussing on the various legal procedures in medical practice. So, we have discussed previously in this module about medical jurisprudence and the forensic science about the duties of doctors definitely in their clinical practice, as we have mentioned in the court also that further what are the legal procedures are there, we will discuss in this lecture. And we have discussed the various evidence law and admissibility of forensic evidences in the courts of law in the previous lectures. So, today with the duties of doctors in a clinical practice and then further in a court, how to give a testimony, how if being called to someone never be fearful or anxious, and how to proceed the various in the summon, how to give an evidence in the court of law and the various legal procedures. So, these all we will discuss in this lecture also in continuation with the previous lectures. So, the various topics or the important concepts which we will cover in this lecture are the inquest. Inquest means inquiry into the investigation, what could be the cause or how to proceed with an investigation, that is the inquest. The various types of inquest are there, which is being the police inquest and the magistrate inquest. Being the most common in India is the police inquest, but there are the various other types of inquest also, that is the medical examiner system as well as the coroner inquest. Another, the witness examination, the expert witness, common witness, and the defense of insanity, the role of doctors in the same, how the insanity can be as a defense in a court of law. So, all these concepts we will discuss in this lecture, but in continuation with the previous lecture, so that you can make a link or whatever being missed that we have mentioned in this lecture along with the duties of doctors. So, the important keywords which we have used in this lecture is a perjury. Perjury is very important, that keyword, that means if any false information you have given in the court of law or any evidence is being hidden, so that come under perjury. The inquest or inquiry, autopsy, that is a postmortem examination, false evidence, expert witness or expert medical witness. So, these are the very important keywords we will understand in this lecture. So, how we can proceed with the various legal procedures. So, what all can be there in the routine medical practice, or what all the legal part being involved in the routine clinical practice, so that doctor has to face in a further court proceedings. So, the legal procedures encompasses several aspects such as the inquest, examination, that is examination means in a court, that is a chief examination, even cross examination. Chief examination means examination in chief by the public prosecutor, we call it very famous PP. So, another cross examination, third re-examination, and sometimes even questioned by the judge. So, that examination mean, and the courtroom procedures. Each instances of a suspicious death in India is thoroughly examined with one of the primary goals being to ascertain the manner in which death has occurred. It is very important. Definitely it is important when has occurred, the time, the cause, but manner is very much important, because we have to find out the accused. Sometimes it is a suicidal death, accidental death, but homicidal. Homicide means there is a culprit. This accused have to be given a punishment, because to further we have to prevent it. And why such that accident has occurred? So, the accidental, so that the community or the authorities has to decide on that particular the reason of that accident has occurred, whether the railway accident, road traffic accident, or anything, accidental poisoning. So, that source of poison being available in the market, or the suicidal. So, anything. So, that we have to make in rules and guidelines for the authorities. The first culprit, then the government can also, or the higher authorities can also be culprit. So, they have to make a guidelines, and so such things. So, suicidal may be the mental issues of a patient. So, it is very much necessary to ascertain the manner in which the death occurred. An autopsy, that is a postmortem examination, is a crucial component, that is very much important of the death investigation process. So, death investigation are performed through inquests, which are overseen by the police, or in certain instances by magistrate. So, anybody can perform, but most common type being the police inquest in India. But in very important instances, that which comes under the custody of police, police firing death, the exhumation, or the woman deaths occurring within a 7 years of marriage. So, in the various aspects, they are very important, in which even police is also being involved. So, in that magistrate inquest is necessary. Prior to forming opinions, the police and the autopsy physician typically exchange their results, and the court depend on the evidence of the autopsy physician, or the autopsy, or the forensic pathologist expert. Typically, the forensic pathologist provides their provisional opinion solely on the cause of death. In a court of law, a doctor can be called upon, that is being summoned, to give their testimony, and is obligated to respond to all inquiries directed towards them. The physician should meticulously document a comprehensive medical history and carefully evaluate the nature of the injuries to determine if they meet the criteria for classification as a medical legal case. If the individual possesses a mobile location code, okay. So, that also being mentioned as MLC, but MLC as a particular the term medical legal case. So, never get confused, MLC is particular term for a medical legal case, but in this slide it is being told mobile location code. So, if the individual possesses that mobile location code, it is imperative that they promptly notify the closest police station about that medical legal case. So, the various legal procedures, what are there? So, that we will discuss are, the first and foremost is the inquest. An inquest refers to the inquiry or investigation conducted to determine the cause of death, particularly in cases that are sudden, suspicious, or unnatural. The Criminal Procedure Code does not provide a clear definition of the term inquest. So, the inquest clearly means, says, the inquiry or investigation into cause of death. An inquest is a legal or judicial investigation conducted to determine the facts. According to the definition provided by the Black's Law Dictionary, an inquest refers to an investigation carried out by medical professionals or occasionally with the assistance of a jury to determine the cause of death of an individual who has passed away under questionable circumstances or while in prison. The regulation pertaining to the inquest report are addressed in the chapter 12 of the code. So, that means that the investigation carried out by medical professional, that means the medical examiner system, but it is not occurring in India. In India, the police, the law enforcement agencies, police, sometimes magistrate. So, they do the inquiry, but it is always good to be as a team, as a medical examiner system or a coroner inquest. So, the best inquest in world is the medical examiner system, where hold as a teamwork. The whoever being performed, forensic pathologist who will do the postmortem, he or she will be the main lead role in that whole team in a, from the scene of crime doing the post-mortem, collecting the evidence, doing the laboratory work. So, under his guidance, his or her guidance will do the investigation. So, that is why the medical examination system is the best, but in India the police inquest is most common and all have the different roles. They perform accordingly and give a conclusion by the forensic pathologist after receiving all the reports. So, this is an inquest scenario in India. So, the police inquest, the sub inspector, who is typically the officer in charge of the police station, carries out the inquest as per the section 174 of the criminal procedure code. So, it is a sub inspector rank. So, but it is not necessarily, the head constable can also come up for an inquest with doing the police inquest for going towards a postmortem examination, but it is always good to be done at least at the rank of sub inspector, so that the the investigation process should go smoothly and properly. Upon receiving the information of a suicide, homicide, accidental death or suspicious death, the officer in charge of the police station promptly notifies the nearest executive magistrate authorized to conduct the investigation. So, how it all happened, the inquest, what is the procedure or what is the flow chart of that is that whenever any incident happened, so someone will notify to the police or the nearest police thana. So, whenever the information being received, the in charge of that police station will inform his executive magistrate that such incident has happened. So, the magistrate will say that after seeing the, after considering hearing the circumstances of that case, that okay, so such is the case, you can proceed, police can proceed, but such is a very severe or very heinous crime. So, magistrate inquest is being needed. So, with the help of police, the magistrate inquest will do. Mostly the magistrate will inform that okay, this is a police inquest part, police case, police inquest can proceed. So, like this the whole inquest procedure goes, but each and every case happened or being notified to the police will be informed to the nearest executive magistrate to conduct the further investigation. The officer then proceeds to the location where the deceased person's body is found. In accordance with the section 175 of the criminal procedure code, conduct an inquiry in the presence of an at least 2 reputable individual, also known as panchas. So, the name, the word itself says panchas, that is a panchnama, panch. Okay. So, the panchnama is being prepared, that is a inquest, okay, the inquiry being conducted under 175 of CRPC. The medical practitioner compiles a report detailing the evident cause of death, outlining the wounds, fractures, bruises and other visible signs of harm discovered on the body. Additionally, the report specifies the method, weapon or the instrument by which these injuries seems to have been. So, after the investigation, so whenever the like investigation is over, that is the inquest part, the police officer in charge of that station and the witness sign the inquest report, which is known as the report which is known as the panchnama. And if there are no suspicions of wrongdoing, the deceased body is released to the family for proper handling and the further disposal, or we should say it as a religiously the cremation or for a further cremation rituals. So, if there are suspicions of wrongdoing or uncertainty, the body is transported to the closest approved government doctor for a postmortem examination. This is done along with a formal request and a copy of the investigation report. So, it is necessary. So, whenever if there is a no suspicion at the scene of crime itself, definitely the things can happen. So, if there is a natural everything, there is a no doubt, definitely the body or the deceased can be given, handed over the body to the relatives. But sometime if as is being not notified, the deceased body has brought to the emergency or to the nearest hospital, where the doctor's duty that this patient, this disease has been brought to the hospital, which is declared as broad dead or even treated and dead after a few hours, have to inform to the police, and then after informing to the police and shift the body to the mortuary. Even the police can come at particular time, can recheck, can identify, can ask the relatives, if there is a no doubt, can release the body. But it is being the broad death, medico legal case, the body belongs to the government, that is a law enforcement agency, police. Doctor should not release the body directly to the relatives, should shift the body if there is a time gap, better always shift the body to the hospital mortuary or to the nearest mortuary and inform to the police. Police comes, they will talk to the relatives, there is no suspicion, can be release body, police will release the body to the relatives. But if there is always, if there is a suspicion, there is any wrongdoing, there is a foul play, there is a third party involvement, definitely there is a proceed for a postmortem examination to find out the cause of death, what is actual thing, with the help of a requisition letter being given to the forensic pathologist, government doctor who will perform the postmortem examination. So, the private medical institutions have the authority to perform medical legal examination and provide the treatment to a living individual. However, the autopsy can only be carried out if granted authorization by the state government. So, the maximum time the autopsy being conducted by the government institutions, but there are the few private medical institutions also where they are being authorized to do the autopsy. That is a very rare or very less in each and every state. So, most of the time the state government or the government medical institution perform the autopsy. The investigation report is transmitted to the magistrate. So, magistrate inquest. So, this was all by the police inquest which is being conducted under 174 of Criminal Procedure Code. While comes to the magistrate inquest which comes under the section 176 of the Criminal Procedure Code. Whenever a death occurs, a magistrate has the authority to carry out an investigation either instead of or in addition to the police investigation as stated in section 176 of the Criminal Procedure Code. As I have told always that any case being whatever being the scenario, whatever being the circumstances, police will inform to the nearest executive magistrate. So, it is a magistrate who decide, who knows all the cases. So, most of the time police does the inquest, but in certain instances the magistrate does the inquest with the help of police or even without. Without means if even police are involved, like custodial police, custodial death, police firing death. The task is carried out by the district magistrate, subdivisional magistrate, tehsildar or any other executive magistrate which has been specifically authorized by the state government executive magistrates under section 20 to 23 of the Criminal Procedure Code. So, what all the circumstances of the magistrate inquest or 176 CRPC being required? The process is carried out in the event of fatalities occurring while in the police custody or during police questioning, or death resulting from the police gunfire, that is a police firing death, deaths occurring in the prisons, reformatories, deaths occurring in the psychiatric hospital, deaths related to the dowry disputes, and cases requiring exhumation. Exhumation refers to the cases of extracting a deceased person's body or the ashes resulting from cremation from their burial sites. Additionally, it might donate the unsettling remnants found within a burial site, particularly when a grave is unsealed for interment. So, whenever there is a need of exhumation, so whenever the body is being, deceased body is being buried with incomplete postmortem examination, or even the first postmortem examination has been done, but still there is a doubtful. So, there can be a court order to do the re-postmortem examination or the second autopsy, second postmortem examination. So, the exhumation being carried out. Exhumation means dig out the burial body with the court order. So, in that case the magistrate inquest being necessary done by the executive magistrate. If a person dies or goes missing, or if a woman alleges that she has been sexually assaulted, raped, while that person or woman is in the custody of the police or any other authorized custody by the court, the relevant section of the Criminal Procedure Code apply. So, in these instances or the scenarios where the magistrate inquest being mandatory. So, the examination of the witnesses. So, the legal procedures what I was talking about. So, we discussed about the inquest, there is the police inquest, the magistrate inquest. Complete detailed is also there. Definitely we can go through the further readings. So, the examination of the witness, which by the either the common witness or even the expert witness, whoever comes for that giving their testimony in the court of law, they will face these three main examination, that is examination in chief by the public prosecutor, cross examination by the defense lawyer, re-examination again if needed by the public prosecutor, and the questions by the judge can be asked at any point of time. So, and the cross examination means the leading question being asked in the form of yes or no. So, these are the further the examinations being carried out in the court of law while giving the testimony by the witnesses. So, the examination of the witnesses is a crucial principle in which a witness is required to affirm the veracity of their statements to ensure the preservation of the evidence integrity. It plays a crucial role in both criminal and the civil trials. The section 45 of the Indian Evidence Act 1872 deals with expert evidence and are defined as someone who possesses exceptional proficiency in a specific domain. So, there is a common witness like the person who has seen the incident by a naked eye. So, doctor can also be a common witness, he can see the incident happen, but also he or she as a doctor, as an expertise, he or she is specialized in specific domain. So, is also known as the expert witness. So, because of the expert witness, he or she gives a testimony in a case, whoever are being treated by them. So, the expert medical witnesses, the primary function of a expert medical witness is to offer an unbiased medical assessment to a court, tribunal or a committee. Individuals are entitled to express their subjective viewpoint of the matter, irrespective of whether they have provided medical care to the victim. For instance, a physician can provide their expert analysis regarding the underlying cause of mortality and the impact of toxic substances. The examination in chief. The court processes for examination in chief are governed by section 137 of Indian Evidence Act. It is alternatively referred to as direct examination. In criminal trials, the state assumes the role of a party, so placing the burden of a proof solely on the prosecution. The accused is deemed innocent until proven otherwise. The medical witness is typically inquired about the initial encounter with the body and the timing of the postmortem examination. During the examination in chief, the question on the description of the injuries, length of the injuries and the weapon used in the offence is also asked. So, even a detailed information, whatever being the report is signed by the treating doctor, forensic pathologist who has done the autopsy or postmortem examination, whatever being the report submitted in the form of whatever the injuries, the length of injuries, the time of death, the cause of death, what are the important findings, or if you can suggest with the help of injuries, what could be the weapon, it can be the blunt weapon, the sharp weapon, sharp can be the single edged or double edged, can be the firearm weapon. So, what all, or can be the poison. So, anything, or can be the accelerant, the petrol, diesel. So, anything, whatever being the report or the evidence or the findings being found out by the expert witness can be asked during the examination in chief by the public prosecutor. So, the cross examination, the defense attorney will conduct a cross examination. During this period, the court evaluates whether a specific query warrants a response or not. The court possesses the authority to prohibit a question if its purpose is to offend or intimidate the witness. However, if the inquiry is pertinent to the case, the court is not permitted to prohibit it. The cross examination does not have a specified time constraint. Cross examination has a keep on asking the leading questions. Interrogating doctors during the cross examination serves to validate the medical data they have provided and assesses the precision and validity of their judgments. So, the doctor should not worried about by the cross examination. It is just you have to tell the truth, whatever being the evidence or the findings you have documented, you have to stick on that, whatever being the truth or the facts of the case, that you have to tell with the help of your expertise. Interrogating doctors during cross examination can help identify any inconsistencies or discrepancies in their statement, as well as clarify any ambiguities or uncertainties in their finding. Sometimes any mishappening or a mistake can happen in a findings. So, definitely you should volunteer to accept that, this mistake has happened, I accept, my apology, and can say that, so this is the clarification. So, it is always good to tell the truth in the court. During cross examination, a doctor's trustworthiness and the degree to which their medical evidence is substantiated by dependable medical procedures and the principles are assessed. The defense counsel may endeavor to dispute the medical evidence put forth by the doctor. They could scrutinize the precision of the medical examination or dispute the interpretation of the findings. The defense counsel may attempt to undermine the reliability of the medical report by emphasizing any discrepancy in or inaccuracies in the report, or by scrutinizing the doctor's findings. Medical evidence is a crucial component of the case. It should be noted that other forms of evidence, such as victim's testimony and the witness statements, are also taken into account. So, now after the examination in chief and cross examination, there are some changes can be there in an examination in chief to be done by the public prosecutor. So, there is a need of re-examination. It is not always necessary to do the re-examination by the public prosecutor, but sometimes it is being needed after hearing the cross examination. So, the primary objective of re-examination is to elucidate the issues presented during cross examination and rectify any errors made. Nevertheless, the lawyer must refrain from introducing any novel arguments or evidence during cross examination that have not been previously addressed in the direct examination. Perjury. So, coming to the very important definition under section 191 of the Indian Penal Code. The Indian Penal Code does not explicitly define perjury as a criminal offence. The offence is referred to as false evidence. The perjury meaning is giving the false evidence. So, section 191 of Indian Penal Code says that pertains to the offence of providing false evidence by anyone. It is not necessarily always the expert witness, by anyone, and the witnesses can become hostile, can say the lie, but later on if find out that the witness has said the lie, not the truth, so it will that it is a hiding the evidence, giving the false evidence. So, that person will be under punishment under 191 of Indian Penal Code as perjury, and giving a punishment under section 193 of Indian Penal Code. So, the perjury is a deliberate act of providing false testimony while under oath. So, the penalty prescribed is under section 193 of Indian Penal Code has maximum sentence of 7 years of imprisonment together with a fine. Deliberate creation of fraudulent evidence would result in an additional 3-year extension of the sentence accompanied by a monetary penalty. Punishment would also be imposed for the use of corrupt, false or forged evidence with full awareness of its falsity. The aforementioned action would be subject to legal consequences as per section 196 of the Indian Penal Code. So, if it is being done intentionally, definitely there is a severe punishment. If it is done unintentionally, it has happened, but still that the person will be held liable for a punishment under 193 of IPC, that is a perjury punishment. So, the perjury by the expert witness, if such offence has been done by the doctor who is an expert, it is not being allowed also, not being expected also, but still has happened. So, expert witnesses are legally distinguished from fact witnesses or eyewitnesses. He functions as an advisory figure. The expert witness is responsible for providing the judge with essential scientific standards for evaluating the veracity of the conclusions. This allows the judge to make an unbiased decision by applying these standards to the circumstances of the case. The witness's credibility lies on the reasoning provided to support their conclusions, as well as the evidence and information they provide to substantiate those judgments. The evidence serves solely to validate or clarify direct or indirect evidence. The act of an expert providing an opinion along with the supporting evidence without it being definitive does not amount to perjury. The mere dismissal of expert testimony alone may not justify the commencement of proceedings under section 340 of the Criminal Procedure Code. So, coming to the news clip that says that Santosh Mane's doctor want withdrawal of perjury notice, which is from the year 2013, being taken from the Times of India. So, it is a case of Solapur based psychiatrist Dilip Bhute in his reply filed to the court of additional session judge on the particular day stated that he wished to withdrawal of the perjury notice issued to him for giving false evidence as a defense witness and claiming that bus driver Santosh Mane was suffering from insanity. So, the reply filed through his lawyer said he had given the evidence as a defense witness to assist the court, not make false statement to help the person particular. So, such things can happen. So, the doctor has given as an expert witness, but if the doctor has said the lie as the truth being hidden or given a false evidence, definitely the doctor will also come under perjury. Can be there is a erasure of the name of the doctor from the register temporarily, and sometime can be the permanent if a very repeat offender or very serious perjury or the false evidence have been given by the expert witness. So, the famous case we will discuss, the Jessica Lal murder case, the state versus Siddharth Vasisht in the year 2007. The PS Manoj, ballistic expert involved in this case, was charged with perjury. Prior to the trial court, he was required to provide his expert opinion on the origin of the bullets that were discharged at Jessica. The bench led by the Chief Justice T.S. Thakur acquitted him from the accusations on the ground that it would be unfair to charge an expert witness with perjury, and offence under section 193 of the Indian Penal Code just for altering his initial position. Furthermore, it was asserted that it is impossible to establish a conclusive opinion in such scientific instances. So, another scenario, Salman Salim Khan versus State of Maharashtra appeal in a year 2015. The prosecution in the Salman Khan hit and run case dismissed the testimony of the driver who had given his statement. The prosecution contended that he had perjured himself on the instruction of the defense attorney, and as a result he was being charged with perjury. His admission of the crime exhibited dubious conduct, as it was claimed that Salman Khan was the one driving. So, now coming to the defense of insanity. So, how the insanity can be as a defense? The insanity defense is predominantly employed in the criminal cases. The legal insanity in essence refers to the condition when an individual at the moment of doing an act is afflicted with a mental illness and experiences a significant impairment in their ability to reason. The matter is explicitly shown in the section 84 of the Indian Penal Code, which pertains to an individual lack of capacity to comprehend. That is a famous McNaughton's rule. The insanity defense is a legal construct distinct from a clinical or medical one. Merely experiencing a mental condition is insufficient evidence to establish insanity. In legal proceedings, the duty of proving the defense of insanity lies with the defendant. This burden requires the defendant to demonstrate the defense by a preponderance of the evidence. So, it is necessary to establish the insanity, but there can be a difference between medical insanity and legal insanity, but it is definitely the burden of proof belongs to the defendant. So, the insanity under Indian Penal Code, that is a section 84 of the IPC, which deals with the act of a person of unsound mind. Nothing is an offence which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law. So, this is a very famous McNaughton's rule. It is very much important in as well as medical as a law graduates. So, section 84 of the Indian Penal Code is linked with the person with an unsound mind, the act done by a person who is with an unsound mind or insanity. So, medical insanity versus the legal insanity. It is important to differentiate between the legal insanity and medical insanity. The court's focus is on legal insanity rather than medical insanity. The individuals afflicted with the mental disease are referred to as medical insanity, while legal insanity requires the presence of both mental illness and a diminished capacity for rational thinking. The term legal insanity specifically pertains to the mental condition of an individual at the moment they commit a crime, without any additional implications. This is solely a legal term and has no connection to the different psychiatric illnesses. Section 84 of the Indian Penal Code does not provide any legal protection for individuals who exhibit abnormality of mind, partial hallucination, irresistible impulse, or compulsive behavior due to psychopathy. So, what is the role of doctors in case of insanity defense? Given that the insanity defense is a matter of law rather than the medicine, the court ultimately determines whether to accept or reject this defense, but a psychiatrist's viewpoint is considered. It is very much important with the point of view of a medical professional, definitely that is a person belongs to unsoundness of mind or not. Psychiatrists may be called upon by the court to help determine if a specific mental diseases have impacted an individual's capacity to form the requisite intent, so affecting their legal responsibility. So, psychiatrists are frequently summoned to perform mental health assessments and provide therapy. In addition to treatment, courts may also need additional certification. It includes providing certification of the defendant's mental state at the time of accused offense. In cases where the defendant asserts an insanity plea, to determine the presence or absence of psychiatric illness. A psychiatrist may also be asked to evaluate the ability of an individual to participate in a trial when their mental illness significantly impairs their cognitive, emotional and behavioral functions, therefore affecting their capacity to defend themselves during the legal proceedings, including their current mental state and competence throughout the trial. The psychiatrist has the responsibility to inform the court, elucidate psychiatric matters, offer truthful and unbiased judgment based on factual information and diagnosis. So, it is very much important role of the psychiatrist in case of proving the legal as well as the medical insanity. So, the famous judgment case, the Ratanlal versus State of Madhya Pradesh, the appellant was apprehended for deliberately igniting the vegetation in an unoccupied area of Nemichan. When questioned about his actions, he definitely responded, "I set it ablaze, take whatever action you deem necessary." The appellant was accused of violating section 435 of the Indian Penal Code, which pertains to the intentionally causing harm through the use of fire. So, as to the psychiatrist's assessment, he met the criteria for being classified as a lunatic under the Indian Lunacy Act of 1912. The report unequivocally stated that the individual exhibits symptoms of persistent low mood, social withdrawal and a mental condition characterized by both depression and psychosis. Consequently, therapy is necessary for their treatment. The trial court determined that the accused was not culpable and hence should not be subjected to punishment. The state lodged an appeal and the High Court overturned the trial's conclusion, holding the accused responsible for the offence. Subsequently, the Supreme Court granted the appeal, resulting in the nullification of the conviction due to two significant factors that are based on medical evidence presented and the observed behavior of the accused at the time of the incident. These factors suggested that the accused met the criteria for the insanity as defined in the section 84 of the Indian Penal Code. So, the apex court, the Supreme Court has considered that on basis of the very significant factors that the accused comes under the insanity, that is the section 84 of the Indian Penal Code. So, coming to the conclusion of our lecture about the various legal procedures, it is important essentially for every doctor to have in mind that their expertise and assistance may be needed in legal and judicial proceedings. Therefore, the police and the law enforcement agencies may seek their aid in multitude of events and situations. It is essential for him or her to attend to the medico legal responsibilities when carrying out his obligation as a caregiver or a life saver. So, nothing to worry about by the treating doctor or the physician side in case of any medico legal case. Just follow the guidelines, do properly, do truthfully with honest, serve the humanity and give a truthful testimony, honestly testimony in a court of law. Nothing to worry about, nothing to be anxious, follow the legal procedures properly. So, it is also the responsibility of a medical practitioner to follow the guidelines in a medical legal case and proceed accordingly and help in the administration of justice to the victim involved in a particular medical legal case. So, these are the references. The students, the volunteers, the viewers can go through these for further readings. So, they are the various PubMed articles and the sites and the news clips which we have taken from the Times of India. Thank you very much.